Rarely has a president gone so far to avoid scrutiny of his taxes. Donald Trump just secured the deal of a lifetime. His own Justice Department quietly signed an agreement forever barring any audit of Trump, his family, or his business interests.
They're the only citizens that can't be audited by the IRS. This is just unbelievable.
Yet one more example of President Trump and his family seeking to profit off the presidency.
The astonishing deal was added to a settlement between Trump and the Internal Revenue Service after Trump sued the IRS for $10 billion over the leak of his tax returns.
I wasn't involved in the settlement. I could have been involved, but I didn't choose to be.
This week, Trump dropped the lawsuit in exchange for the creation of a $1.8 billion fund meant to compensate the victims of alleged political prosecutions. Even Republicans are balking.
I think that there are and will be, continue to be, a lot of questions around that the administration is going to have to answer.
Hey family, welcome back. Adam with you once again. A president striking a deal to permanently immunize himself and his family from IRS audits, shielding personal and business filings from scrutiny. The power to avoid financial oversight from the very government he leads is the ultimate protection. A federal judge just obliterated a deal Trump had struck to permanently immunize himself, his family, and his business from IRS audits, a legal shield his own administration constructed. The ruling sent shockwaves through Washington and strikes at the heart of how power is supposed to operate in a democracy. Most Americans have no idea this happened. Let me take you back to the beginning of this extraordinary legal journey, because understanding how we got here is essential to grasping just how unprecedented this entire situation really is.
Yesterday, the Trump Justice Department said it was ending that $1.8 billion fund designed to pay people who can show they were politically targeted by the Biden administration. Well, today, the president would not commit to ending it, and the Justice Department confirmed this extraordinary fact. The president and his family are set to be shielded from IRS audits for taxes already filed. Senior White House and political correspondent Ed O'Keefe is here with more.
Tony, good to see you. The president today called the idea of establishing what the White House calls an anti-weaponization fund, quote, the greatest thing. And under repeated questioning, he wouldn't say whether he's agreed to drop plans for the fund. The acting attorney general had told lawmakers plans for the fund would be dropped after a federal judge temporarily blocked establishing it. But fierce bipartisan opposition to the fund also appeared to spike it, as members of both parties worried it might one day be used to compensate people pardoned for crimes committed during the January 6th insurrection. Now, even with the fate of the fund unclear, the DOJ is standing by a settlement between Trump, his family, and the IRS. The tax agency has agreed to shield the president and his family from audits, settling a $10 billion lawsuit over the unauthorized release of Trump's tax returns.
The president filed a massive lawsuit against the IRS, seeking $10 billion in damages. The basis of that lawsuit was entirely legitimate on its face. A former IRS contractor named Charles Littlejohn had illegally leaked confidential tax return information belonging to Trump and other wealthy Americans. Littlejohn provided that data to media outlets, was caught, prosecuted, pleaded guilty, and was sentenced to prison. There was genuine harm done here. Real legal liability existed on the part of the government. When someone's private financial information is illegally disclosed by a government employee, there are real consequences and legitimate claims for damages. Most legal observers would agree that the IRS had genuine exposure in this situation. The lawsuit itself was not crazy. It was not fabricated out of thin air. There was a real hook to hang it on. But here is where things took a sharp turn into uncharted territory. Rather than allowing this lawsuit to proceed through the normal court process, allowing a judge to evaluate the evidence and determine an appropriate remedy based on the actual harm suffered.
President Donald Trump and the Justice Department have reached a settlement on the president's $10 billion lawsuit against the IRS. Mr. Trump's acting attorney general Todd Blanche announced the president and other plaintiffs in the suit will receive formal apologies, but no monetary payments. The lawsuit claimed that the IRS allowed a government contractor to leak President Trump's tax returns. So let's talk about this one. Live to CBS News Justice reporter Jake Rosen in Washington. So Jake, why the change in course?
Well, we saw a couple of weeks ago read that both parties, the IRS and the Justice Department, moved in this lawsuit to postpone any deadlines for 90 days, as they said they wanted to reach some kind of agreement to stop, quote, prolonged litigation. What that was turns out to be a 1.776, note that reads 1776, for likely America's 250th birthday coming up in a month and a half, settlement with the Department of Justice. In exchange for that, President Trump will not directly get that money. However, it will create essentially a anti-weaponization fund, in the words of the Justice Department, which will be used to potentially pay out allies. Think about people like former General Michael Flynn and a number of other people who have reached settlements with the Department of Justice.
The president's own Justice Department stepped in and settled the case with itself. And the settlement they reached was not remotely proportional to the injury. It was extraordinary in ways that had never been seen before in American legal history. The agreement that emerged from this internal government negotiation contained language that was truly shocking. I want to be incredibly precise here, because the actual wording from the document is so stunning that it almost defies belief. The settlement stated that the government was permanently barred and precluded from pursuing any audits, examinations, or related reviews of Trump and his family, and his business tax returns filed before a specific date. Permanently barred and precluded. Those are the actual words lifted directly from the signed legal document. The government of the United States, the administration run by the man who was also the plaintiff in this lawsuit, made a deal to permanently protect that same man from IRS scrutiny covering his entire financial history. Think about the implications of that for a moment.
This settlement between Donald Trump and the US government is now legally invalid. The agreement had granted the president immunity from tax audits and set up a fund to compensate Trump allies who believed they'd been unjustly persecuted. On Monday, federal judge Kathleen Williams argued the initial lawsuit was filed in bad faith and the result was collusive. She found the two parties did not have opposing interests. Trump, the plaintiff, was president and therefore in charge of the Internal Revenue Service, the defendant.
This was an attempt to use the court to provide some legitimacy to an agreement to confer immunity to people and entities affiliated with the president, and to earmark billions of dollars from American taxpayers to redress grievances not defined in the law.
Nearly every president since Richard Nixon has voluntarily released their tax records, but Trump became the exception when he refused to do so during his first term. In 2019, a contractor leaked more than 2 decades of his tax information to the press. In January of this year, Trump, his sons Eric and Donald Jr., and the Trump Organization sued the IRS and the Treasury Department for $10 billion, alleging the government failed to prevent the unlawful disclosure of the president's tax returns.
The Internal Revenue Service, the agency responsible for enforcing tax compliance across the entire country, was contractually prohibited from ever looking at the tax returns of the sitting president, his family, and his business empire. That is not normal. That is not how civil litigation works. That is not how government is supposed to function. The IRS has a statutory obligation to enforce tax compliance for every taxpayer in the country, regardless of who they are or what office they hold. Permanently exempting the commander-in-chief from that process is the kind of arrangement that raises fundamental questions about whether we have one system of justice for the powerful and another for everyone else. Section 1, the unprecedented deal, and the judge who shattered it. Now, let me introduce you to the federal judge who looked at this entire arrangement and simply refused to accept it. This jurist did not quietly void the settlement and move on. She went far beyond that. She found that the underlying lawsuit itself had been brought for what she called improper purposes. That is a specific legal finding that carries enormous weight. When a federal judge says a lawsuit was brought for improper purposes, she is saying this was not a legitimate use of the court system. Something else was going on here, something that undermined the integrity of the judicial process. She referred a Trump attorney involved in the case for possible professional discipline. She ruled that Trump and anyone connected to the deal cannot rely on it in any future legal proceedings. She declared the entire arrangement void and unenforceable. This was not a slap on the wrist. This was not a procedural technicality. This was a scorched earth ruling that dismantled the entire legal structure that had been constructed to protect the president from scrutiny. The judge essentially said, I see what happened here, I do not accept it, and I am going to make sure no one ever tries this again. That is a powerful moment in American jurisprudence. A single federal judge standing up to the combined power of the presidency and the Justice Department and saying, no, this is not how our system works. It is the kind of institutional courage that the founders envisioned when they created an independent judiciary designed to check the other branches of government. But here's where the story gets even more complicated and frankly more concerning. The settlement also included something else that most coverage has completely overlooked. There was a separate proposed fund worth $1.8 billion that was supposed to compensate people who claimed they had been politically targeted by the federal government. That fund was later rescinded and no payments were ever made from it. But the fact that it was part of the same overall arrangement tells you something crucial about the scope of what was being attempted here. This was not a simple lawsuit to recover damages for a real harm. This was a package deal. A comprehensive legal maneuver that sought to accomplish multiple objectives simultaneously. Protect the president from future IRS scrutiny. Create a massive compensation fund for people who claimed political persecution. And do it all through a settlement that bypassed the normal judicial process that would have provided public scrutiny and accountability. When you step back and look at the full picture, the permanent audit protection, the massive compensation fund, the Attorney General nominee who signed off on all of it, and a federal judge who just tore the whole thing down, you get a story that is genuinely unprecedented in American legal history. There is no precedent for this, no comparable situation, no historical analog. We are in entirely new territory here. Let's think carefully about what the judge's ruling actually does and does not accomplish, because getting this distinction right is absolutely crucial to understanding the significance of this moment. The ruling voids the settlement entirely. The permanent audit protection language is gone. The IRS is no longer contractually barred from doing its job when it comes to Trump-related tax matters. That is a significant and real change from where things stood. The legal shield that had been constructed has been judicially dismantled. But here is the important caveat that many people are missing. The ruling does not establish that Trump committed tax fraud. It does not guarantee that any audit will actually happen. It does not mean that if an audit did happen, it would find wrongdoing. What it means is that the unusual contractual protection Trump's DOJ had put in place has been removed. The IRS is now back in the position it would have been in if this settlement had never existed. It can approach Trump-related tax filings the same way it would approach any other large, complex taxpayer. That is the accurate and careful framing. And it is important to hold on to that distinction because a lot of coverage is jumping from this ruling to conclusions about criminal tax evasion that no court has actually reached. The ruling is about the process, about the institutional self-dealing, about a government that tried to exempt its own leader from accountability, not a proven finding of tax crime. Those are very different things, and being accurate about the difference is what makes this story credible and worth taking seriously on its own merits. Now, let's talk about the self-dealing dimension, because this is where the story becomes historically significant in a way that transcends any particular political figure. Consider what actually happened here from a pure institutional standpoint. The president filed a personal lawsuit against a federal agency that operates within his own executive branch. His own Justice Department, which he controls through his appointees, settled that lawsuit in a way that permanently protected the sitting president from scrutiny by that same federal agency. The DOJ represents the interests of the United States government and the American people. When the DOJ settles a lawsuit involving a federal agency, it is supposed to be looking out for the government's interest, not the personal financial interest of the man currently occupying the White House. The idea that those two things could ever be perfectly aligned that what benefits Trump personally is automatically the same as what benefits the country is exactly the conflict of interest that the entire institutional design of the executive branch is supposed to prevent. Ethical walls, recusal requirements, chains of accountability between the White House and the DOJ. All of these safeguards are designed to keep personal interests from contaminating law enforcement decisions. Those safeguards appear to have not worked here. The president's personal lawsuit was settled by his own administration in a way that benefited him directly, and it took a federal judge to stop it. What makes this even more remarkable is that NPR specifically reported this appears to be the first known instance of a president settling a lawsuit with his own government in this particular way. The first known instance. That detail should not be buried in paragraph 11 of some obscure news article. It should be the headline. The first time in American history that a sitting president used his own Justice Department to permanently shield himself from the IRS. That is not a partisan talking point. That is a documented fact, a piece of American legal history that will be studied by scholars for generations to come. And the only reason we even know about it is because a federal judge had the courage to call it what it was and strike it down. Think about what would have happened if that judge had not intervened. The settlement would have remained in place. The permanent audit protection would have stood. The president's tax returns would have been forever shielded from scrutiny, and no one would have ever known what could have been found. That is the terrifying possibility that this case exposes. The potential for an administration to use the machinery of government to protect itself from accountability. And the only bulwark against that abuse is an independent judiciary willing to say no. Now, let's bring Todd Blanche directly into this narrative, because his role is not a footnote. It is central to understanding why this story is not going away anytime soon. Blanche signed off on the audit protection language inside the settlement agreement. He was the one who put his name on a document that permanently barred the IRS from auditing the president's tax returns. Blanche is also right now Trump's nominee to be the permanent Attorney General of the United States. The man who approved this extraordinary legal arrangement is being considered to permanently lead the very institution that produced it. He is also the man who spent years as Trump's personal criminal defense attorney, representing him through multiple indictments and legal battles. His Senate confirmation is currently stalled because Republican Senators John Cornyn and Tom Tillis have raised documented concerns about whether he can truly operate independently of his former client. And now this judge's ruling lands directly on top of all of that friction. The DOJ has stated that Blanche is complying with applicable recusals in his current acting role. But this ruling raises a direct and uncomfortable question that nobody in Washington is asking loudly enough right now. When this settlement was being put together, when the language permanently barring IRS audits of Trump was being drafted and signed, where were the recusals? Where were the ethical firewalls that are supposed to be built into this process? Where was the person whose job it was to pump the brakes and say, wait, we are the Department of Justice. We represent the American people. We cannot be in the business of permanently exempting the sitting president from his own federal tax agency's oversight. The judge's finding that the lawsuit was brought for improper purposes suggests those internal controls did not function the way they are designed to. And the man whose name is on the deal, that a judge called improper, is the same man being considered to permanently lead the institution that produced it. That is a problem. That is a deeply serious institutional problem that every senator voting on Blanche's confirmation has to reckon with. How can someone who approved a settlement that a federal judge later declared improper be trusted to lead the Justice Department? How can senators look their constituents in the eye and say that this is the person who will ensure that justice is applied equally to everyone, regardless of their political connections? Those are not rhetorical questions. Those are the questions that will define Blanche's confirmation hearings. And the answers that are given will tell us a great deal about whether the Senate is willing to exercise its constitutional responsibility to provide advice and consent, or whether it will simply rubber stamp whatever the administration wants. And then there is Congress. The congressional angle has more teeth than people are giving it credit for. Senator Elizabeth Warren, Chuck Schumer, and Ron Wyden opened a formal inquiry into whether Trump-affiliated companies benefited from what they call get-out-of-jail-free cards through this settlement arrangement. To be completely straight with you, that language is the senator's allegation. It is not a judicial finding. The judge used the phrase improper purposes, which is a specific legal term in civil litigation, meaning the lawsuit was not brought for a legitimate legal reason. That is meaningfully different from a court calling this a deliberate criminal scheme to evade tax accountability. So when you see that get out of jail free framing in news coverage, understand it is coming from Democratic senators making a political argument, not from the court. The factual core of this story, the deal existed, it gave sweeping audit protections, and a judge voided it as improper, is strong enough to stand entirely on its own. It does not need embellishment. It does not need partisan framing. The reality is shocking enough on its face. But here is what does matter about the congressional inquiry, regardless of the framing. Formal Senate investigations generate subpoenas. They generate document production. They put witnesses on the record under oath. They create accountability mechanisms that run parallel to whatever the courts are doing. And with the political landscape constantly shifting, this story of Trump's DOJ entering an unprecedented settlement that a judge later voided for improper purposes is exactly the kind of substantive institutional accountability argument that is going to stay alive in the political conversation for a very long time. There is also a dimension here that connects directly to the broader debate about what the DOJ is and is not supposed to do. When we talk about DOJ independence, when senators debate whether a nominee can operate independently of the president who put him there, this IRS settlement is the single most concrete example of what a non-independent DOJ looks like in practice. It is not abstract, it is not theoretical, it is a signed document with specific language that permanently carved out a legal protection for the president from a federal agency the president oversees. The fact that it took a federal judge to stop it rather than internal accountability mechanisms tells you everything you need to know about the state of those mechanisms. The internal safeguards failed. The ethical walls didn't hold. The recusal requirements didn't function. And the only reason we are having this conversation at all is because one federal judge had the courage and the independence to say, this is not acceptable. That should terrify anyone who believes in the rule of law. Because what happens when there isn't a judge willing to step in? What happens when an administration manages to push something like this through without anyone noticing until it's too late? These are the questions that this case forces us to confront. Let's bring it all the way home now and consider the full implications of what has happened here. The President of the United States used his own Justice Department to settle his personal lawsuit in a way that permanently shielded him and his family and businesses from federal tax oversight. The DOJ is not supposed to work that way. The whole structural design of the executive branch, the ethical walls, the recusal requirements, the firewalls between the White House and federal law enforcement, all of these exist precisely to prevent the president from directing his own government toward his personal benefit. And those safeguards did not hold. A federal judge had to step in and void the arrangement after it had already been signed. In effect, the internal checks that are supposed to catch this before it happens failed. And here is the downstream consequence that deserves far more discussion than it is currently receiving. If this administration can use the DOJ to settle the president's personal lawsuit in a way that permanently exempts him from IRS scrutiny, and the only correction comes from a single federal judge after the fact, then the next president can try the same thing. And the one after that. Every future administration now knows this kind of arrangement can be constructed. The question is whether there will always be a judge with the judicial independence and institutional confidence to shut it down. Counting on that is not a system, it is a prayer. And prayers are not a substitute for institutional safeguards that actually function. Now look, some people watching this are going to say, well, This is just Democrats and judges going after Trump again. And I understand why that framing is appealing if you are skeptical of the way Trump's legal battles have played out. But here's the thing. The judge who voided this deal did not do it because she dislikes Trump. She did it because the lawsuit was found to have been brought for improper purposes, a legal standard that applies to everyone equally. The same standard would apply if a Democratic president had tried to do the same thing. The same standard would apply if any president tried to use his own Justice Department to permanently shield himself from the IRS. That is what makes this a genuinely nonpartisan institutional story underneath all the political noise. The partisan angles exist, absolutely. The Democrats running the congressional inquiry have political motivations, but the legal ruling itself is grounded in principle, not politics. And the principle being protected that the president cannot use the machinery of federal law enforcement as a personal legal shield is one that should matter to every American, regardless of party. Because a government that applies the law equally to everyone, including the person at the top, is the foundation everything else rests on. And when that foundation gets tested, when someone tries to carve out an exception for themselves using the power of the office, the correction has to come from somewhere. This time, it came from a federal judge. Next time, it might not. So where does this story go from here? A few threads to watch that will keep this alive and evolving for the foreseeable future. The congressional inquiry is active and will generate documents and hearings that keep this in the public eye. Todd Blanche's confirmation fight in the Senate now has an additional concrete layer of difficulty. Every senator voting on his nomination has to weigh his role in signing off on a settlement a federal judge later called improper. Republican senators who were already hesitant on Blanche now have one more documented concern to justify their position. And the broader question of whether the IRS will actually now review Trump-related tax matters, now that the contractual bar has been lifted by the court, is an open and ongoing question that will resurface with every related development that comes out of this case over the coming months. The man who signed off on the audit protection is currently being considered to permanently run the Justice Department that produced it. That connection is not going to fade away. It is going to be examined, debated, and litigated in the court of public opinion and potentially in the courts themselves. Let me leave you with the line that cuts through all of the noise and complexity. A federal judge found that a sitting president's administration brought a lawsuit against a federal agency for improper purposes and used that lawsuit to permanently shield the president himself from that agency's oversight. She voided it. She referred a lawyer for discipline. She blocked anyone from relying on it again. That is what happened. That is documented, that is verified. And the man who signed off on the audit protection is currently being considered to permanently run the Justice Department that produced it. This is not a story about partisan bickering. This is not a story about liberal judges versus conservative presidents. This is a story about the rule of law, about whether the president is above the law or subject to it, about whether the Justice Department serves the American people or the personal interests of the man in the Oval Office, and about whether we have institutional safeguards that actually work, or whether we are simply relying on the hope that someone somewhere will have the courage to say no when the system breaks down. The judge said no, she did her job, but the fact that she had to is the real story here. The fact that no one inside the administration said no before it got to her. The fact that this deal was signed and finalized and would have remained in place forever if not for judicial intervention. That is the part that should keep every American awake at night. Because next time, there might not be a judge. Next time, there might not be anyone willing to stand up and say that the emperor has no clothes. And when that happens, we will have lost something fundamental about what it means to live in a country governed by laws rather than by men. The story of this settlement is not over, it is just beginning. And the outcome will tell us a great deal about the kind of country we are becoming.